Welcome back to Winning Isn't Easy. Let's talk about the not so independent medical evaluations, and we're going to talk about it specifically in the context of a Lincoln National case that ultimately resulted in a denial of a fibromyalgia claim. Now, when you apply for your disability insurance benefits, you need to understand that many disability insurance policies or plans have a provision that allow the disability carrier plan to have what's called an independent medical evaluation by a physician of their choice and at a frequency that they decide. Depending on the nature of your medical condition, it is not always common for the carrier to have an independent medical evaluation when you apply for your disability insurance benefits. Often this comes after you have been paid benefits for a while, or your medical condition changes or doesn't change, or when the definition of disability changes from an inability to do your own occupation to an inability to do any occupation. And those are the situations in which I see carriers generally exercise their rights to the not so independent IME. So let me give you an example. Let's say you have fibromyalgia. One of the most common complaints of fibromyalgia is brain fog, forgetfulness, and cognitive issues. And the problem with those kinds of complaints is that they're subjective symptoms. They're hard to verify with testing. And in many cases, a person's medical records will show a normal, what's called a mini mental status exam. That means that they're oriented to time and place. So what date is it? Where are you at? Who's the president? Now, what we will see is that disability insurance carriers or plans will say, there's no brain fog here. They knew where they were, when they were, and who the president was. Can't be disabled. We're going to deny the claim. Now, what they also may do is to supplement the basis of that denial by a not so independent medical evaluation. And again, the insurance companies are going to stack the deck. They're not going to use a physician who is going to render a truthful opinion. What they're trying to do is to set up this claim for claims denial. Now, it doesn't matter if you've got fibromyalgia, it doesn't matter if you've got back pain. The game is the same. The IME doctor is being hired to render an opinion that you don't meet the disability terms of the policy, or that your restrictions and limitations are such that you can go back to your past occupation, your own occupation, or do other occupations, or even to disagree with your doctor's opinion about restrictions and limitations and treatment. They use IMEs for all sorts of purposes, but the underlying reason is to either deny the claim or to support that the denial or termination. So let me give you an example. This is a case of Copeland versus the Lincoln National Insurance Company. It's a case out of the Western District of Michigan in 2024. Ms. Copeland was a former software analyst, and she stopped working in 2016 due to epilepsy, fibromyalgia, depression, degenerative back disease, and medication side effects. So in the course of the claim, Lincoln arranged for cognitive and neurological testing. As to be expected, their neuropsychologist found no significant deficits. She was alert, oriented, had no speech issues. She remained on task. So what Lincoln did is say, hey, look, there's no objective evidence to support your complaints of brain fog and problems with comprehension or staying on task. They also said, look, there's not a lot of objective evidence in terms of contemporaneous medical records that show that you have a cognitive decline that would prevent you from doing your job. So in other words, you were doing your job. There was no reason why you stopped working. You were unhappy. Let's make up a reason as to why you stopped working, but that reason has nothing to do with the progression of your disease or symptoms. Typically what we see. They're going to have a peer review doctor internally cherry pick the medical records and create a reason to justify a claims denial. No objective evidence. Complaints are out of proportion to the exam findings. I think the restrictions, limitations are X, and we disagree with the treating doctor for Y reasons. We've looked at the social media. We think that the activity is inconsistent with what they reported to their doctors. Their complaints are out of proportion. By the way, we've got surveillance film, and even as poor as it might be, showing limited activity, we still think that that's justification for our liar for hire peer review opinions that the claimant's not disabled and can do their own or any occupation. Now, in this particular case, the case went to federal court. And the judge acknowledged that she had multiple health issues, but found that her treating doctor's opinions were based on subjective complaints without objective support. The problem here in a case like this is her doctors didn't dispute the test results and didn't explain why her symptoms prevented her from performing her own occupation. Now, the court said, look, we're very sympathetic. We know that the symptoms are real, but they don't rise to the level of preventing her from performing her occupation. And the denial was upheld. So as soon as this case was set for an IME, the bell should have gone off. And the lessons that learned are that your records have to document your symptoms, be they physical, be they cognitive, be they psychiatrically. And they have to document the nature, extent, frequency, and duration of the symptoms. The medical records also have to document how those symptoms impact your ability to function, your ability to do your own or any occupation. And any testing should demonstrate measurable deficits. There needs to be objective evidence. And in that respect, you need to understand that ERISA doesn't have a treating physician role. Your doctor's opinion isn't necessarily superior to the peer-reviewed doctors or the IME doctor. So as a result, you need to submit rebuttals from qualified experts. And in doing so, you might want to actually have what's called a functional capacity evaluation, which is an objective measurement of your physical abilities. You might want to have a CPET exam, which is an objective measure of the impact of fatigue. You might want to have neuropsychological testing. In any event, you want to be developing the evidence that rebuts the liar for hire peer-reviewed doctor and the liar for hire IME doctor. In fact, you may want to get your own IME, but you also need to understand that this has to be done, I think, very strategically, based on an understanding of the terms of the policy, based on what's in the medical records, based on what's in those denial letters, and what we as lawyers anticipate the grounds for that appeal are going to be. How are we going to develop the necessary evidence to rebut this? Now, let's talk about those reviewing doctors, those liar for hire doctors who rubber stamp claims denial. You might assume that the insurance company would use somebody in the same specialty. So in the case of fibromyalgia, you might expect that the peer-reviewed doctor would be a rheumatologist. Well, that's not always the case. And I'm going to talk about that in our next segment. In the meantime, let's take a break.